My name is Manish Sharma. I'm Associate General Counsel with the AFL-CIO, and on behalf of the Federation and its affiliates, we would thank you for the opportunity to speak here today.
How are you doing, Manish?
I'm good. How are you? I'll be splitting my time, as you can see, with Elizabeth Bunn, who is Director of Organizing at the AFL-CIO. And because I'm splitting my time, I just want to focus on a few things. As you're aware, the AFL-CIO does not directly represent unions in our case proceedings. Therefore, in order to assist the board in its rulemaking process, we thought it would be useful to provide insights from union-side lawyers who practice in regions across the country. To do so, we conducted a survey of attorneys with extensive experience representing affiliates in representation proceedings. 57 attorneys in that pool responded. As part of my testimony, I want to highlight some of the aspects of that survey and also discuss some vivid examples that were provided by attorneys to illustrate the benefits of these proposed changes. The survey is discussed in more detail in our comments and is appended, the full results are appended to the comments. So I first just want to note that there's wide consensus among experienced union-side attorneys that the current rules fail to provide workers with free and fair elections. As it relates specifically to the statement of position, 69% of the attorneys who responded said that they had been involved in cases where the employer refused to identify the issues it planned to raise at the pre-election hearing until the proceedings went on the record. Additionally, 44% reported involvement in a case where the employer did not identify its issues prior to presenting testimony. One attorney reported to us in a recent R case for an RN unit that she called the employer's counsel after the petition was filed to ask him to identify what issues they might have and to see if the parties might be able to reach a stip. The attorney refused and stated there are always issues. The company then litigated the supervisory status of every charge nurse in the proposed unit. Luckily, the union expended the time and resources to prepare for this potential issue before the hearing and was able to properly respond. But in many cases, the union is not in a position to respond to a company argument as it has no notice that this issue will be raised at the hearing. This type of hide-the-ball litigation serves no purpose but to avoid reaching agreement, create delay, and leave the union in a position to waste resources and by preparing for any and all potential arguments. In addition, the additional requirement, I should say, that employers must include a list of employees with classification, shift, and work location information is integral to this proposed change. The list aids the hearing officer and the parties in understanding issues and allows the union to investigate eligibility and inclusion issues so as not forced to challenge voters unnecessarily or allow ineligible voters to vote. One attorney provided us an example in which the union received an Excelsior list that included more names than the union believed should have been in the unit. The pro-union workers, who unfortunately were fairly unsophisticated, failed to challenge at least 6 voters who ended up having no connection whatsoever to the petition for unit. If the union had the list of employees purportedly in the unit at the time of the pre-election hearing, it could have explored those issues and resolved them then. It should also be noted that the requirement for a written statement of position merely codifies and standardizes an existing informal practice. But as our survey and the examples show, the practice has varied widely and permits strategic behavior, sometimes very explicitly and sometimes abusively, when employers refuse to take a position or change their position in order to prevent agreement and create litigation. And for that reason, we support the requirement for a written statement of position. I yield any time I have remaining to colleague Bunn.